Donna Johansson and the estate of Gary Johansson.
And the court notes that Mr. Casavelli and Ms. Castelli are both here as well. And ma'am, I know I've asked you this before. Do you prefer to be called Castelli or Casavelli? How do you like to be referred to?
You refer to me as Nikki. Casavelli is my married name. Casavelli is maiden name.
Maiden name. Okay, so your formal name is Casavelli. Okay. I'll make a note of that so that I don't have to keep asking you. I recall that you gave me a similar answer, and as time passes, and I need to ask again. All right. We're here on a trial management conference. The idea behind a trial management conference is to make sure that we're all on track. We've got everything in order for the jury trial, the 8-day jury trial that we've got set for early October. So since you're not represented, the defendants aren't represented, I'll stop and explain a few things to you. But let me first ask the defendants, either of you have any experience with jury trials? Have you been through this process before?
No.
Okay. Then I will definitely try to help you kind of manage your expectations and give you some ideas of what's going to happen.
We've been in court before, Your Honor.
Well, jury trial is just a whole other animal.
Well, honestly, we have never been pulled into something like this from a lawyer like this for 7 years.
Gotcha. Okay. Well, you said you haven't been in court before, other than in this case?
We've been in court.
Okay. So I'm just going to try to explain a little bit about what to expect at the jury trial so that you have that information. I've got your unilateral pretrial statements, and I've got my own checklist of things to go through. And what I'd like to do is kind of go through my checklist, cover the areas that I need to cover, and then after that, I'll hear from each of you on whatever you want to address. All right? Make sense? This is an old case. It's a 2017 case. I think I'm your fifth judge. So it's headed to trial. Sixth judge? All right. I've asked you this before, and I've read your pretrial statements on this, but I want to address it again. I'll hear from you first, Mr. East. What do you think the prospects are for, and this won't delay the trial, just what are your thoughts on another settlement conference, either with a judge, which can sometimes be a different experience, or otherwise? Is it futile? Is it possible?
I'm skeptical of that, Your Honor. I mean, it would have to be something where we would, if you ordered it, that we wouldn't lose our trial setting. This is our fifth or sixth firm trial setting, and I wouldn't want to jeopardize that.
Yeah, I won't move the trial date, but we've got time. I could get a judge to preside over a settlement conference. I don't know if you've been through that before.
We had ADR earlier on, probably in 2018, and it was unsuccessful, very unsuccessful.
Okay. So let me give you my pitch for it to the Casavellis, and you can hear your thoughts. What I'm proposing is we don't move the trial date, it'll stay, but we get a judge to preside over a settlement conference for you. Been through a settlement conference, and it sounds like you have some time ago. It'll run.
No, that wasn't a settlement conference.
Okay, so
that was a surrender.
Okay,
and that's he wouldn't compromise on anything.
As an attorney, I would know that you're asking for your entire case, so no.
Okay, so I mean that's the big question: is it going to be productive? But the way it would work would be
that's the question for
right. The way it would be, and maybe I'll give you guys some time to think about it, but the way it would work is a judge would call a case like this and then separate you to different rooms and then work with you individually and try to broker a deal. That's the idea. And sometimes it's a little different, a little better when it's a judicial officer, because there are some judges that do it a lot that are very good at it. And it can be productive when we get close to trial, because then everybody's, it's real. The benefit...
It's been real, Your Honor, for 7 years, but we don't have a choice in this issue. We're here for the ride. We're just trying to make it an adventure instead of an ordeal.
Okay. So let's put a pin in that and think about it some more. What I'm hearing from you is that you would be open to it if you think the plaintiffs would be open to some sort of compromise and not a demand for surrender like what you think you experienced before.
Everything they demand, even though it's not true, but they want us to give everything they demand, that's a surrender. That's not a compromise.
So I hear you. With that, do you have any different thoughts or additional thoughts on a settlement conference with the judge?
Yeah.
Okay. Do you want to think about it, or we should just move on from that issue?
I don't see where it would be productive, Your Honor.
Okay.
I'd like to embarrass him in front of the jury.
Hold on. Okay. I need to hear from you. I know I've said this to you before. I can only hear from you one at a time. Don't want you to interrupt each other. That goes for the trial, too, not just for today. All right. Well, if anyone changes their mind, they can request a settlement conference, and I'll set it up for you. But we don't want to do it if it's not going to be productive.
Well, go ahead. We're open to it. So we'll leave the option to him.
All right. Mr. Eastin, email our chambers and let us know if that's something you want to do.
I will, Your Honor. Thank you.
Okay. Another option, and I'm offering you these options because a jury trial is a very different court proceeding. We're going to have members of the public, 8 to 10 of them, that are going to decide this case. They're going to come at this from their own kind of perspectives and life experiences, and juries are incredibly difficult to predict. You don't know what they're going to do, and I've seen that firsthand. They can come up with things that will shock and surprise you. It is a very different way to resolve your disputes. I talked about negotiated settlement. We'll put that aside, but another option would be to do either a bench trial, which would mean I would be your finder of fact and decision maker on all issues and claims. You know how to make?
Absolutely.
Nothing against me, but
you.
I know, I understand.
There's 5 before you that says.
I'm sorry?
There's 5 judges before you that
have offered that
for us, yes.
Okay. Have you guys thought about binding arbitration or some other way of resolving this?
He doesn't want to talk to us, period. There's nothing to be resolved when he won't talk.
So binding arbitration would be well, I guess if you didn't want a bench trial, you probably don't want an arbitrator, another single decision maker.
He says we're difficult, and we've been not difficult on purpose because we wanted to get through this as easy as possible, but he makes it difficult.
All right. Mr. Eastin, from your side, any interest in either of those things?
Bench trial would be very open to, Your Honor. I think it'd be much more efficient and better use of time, but
We've never signed a waiver for that.
All right. You want a jury trial?
No, we don't want this to be over, but we would like the truth and the evidence to be out there and to be heard instead of being pushed into what's going on.
So a jury, I think you know this, but I'll just say this in case you don't. So a jury trial, the jury's going to make the decision on all the claims in the case, except for the ones that are not jury eligible. If you waive the jury trial and it comes to me, then I will decide all the issues. And if I'm the decision maker, this is not an 8-day trial. It's probably a 5-day trial, so it'll be shorter. If it's a jury trial, you'll get your decision faster because you'll get your verdict at the end of the trial. If it's a bench trial, there'll be some time for me to draw up the verdict. Or I could issue a short verdict followed up by a more substantive verdict later. So that's what I'm talking about. Any further thoughts on whether you're open to a bench trial versus a jury trial, or do you want to proceed with a jury trial?
Well, going honestly, you just want an answer.
I want what you want. I want to know what you want.
I would like our evidence in if we have to go to trial. If not, I'd like the court to understand what the evidence is we're putting instead of denying every motion. And you have denied 11 of them so far. And yet, we have been denied discovery on almost everything for 7 years. In the beginning, we got discovery from Judge Cohen. Then he's been blocking everything.
Okay, so you want a jury trial?
No, I want this to be over with. But if we have to go to jury trial, I would like our evidence in.
Well, the standard of evidence would be the same.
Like towards subpoenas, you're going to let those in because he's asked you to let production in. But
well, we'll talk about evidence in a second. But it'll be the same. If it's a jury trial or a bench trial, the same evidentiary rulings would apply.
Would that mean he has to produce originals?
That's what the rules say.
We'll get to evidence in a second, but evidence the same, either jury trial or bench trial. Thoughts? Do you want to consider it, or do you want to consider it? Okay. Let us know within a week, if that's okay, because we need to do things like order a jury, summon jury members of our public to appear. We've got some work to do if it's a jury trial, so within a week from today.
Okay.
Any questions about that? Anything else I can answer about jury versus bench trial?
Well, it's going to be eight-man jury or eight-person jury?
It's always been brought up for 8. I don't know.
I think I'll look at here. I'll go through it in a second, but it's, I believe, Mr. Eastin, correct me if I'm wrong, it's you propose 8 jurors plus 1 alternate. Is that right?
Sounds right, Your Honor. I'm not.
We'll look at it when we get to it.
Not fresh in my recollection on that.
Yeah, so eight jurors. It's usually 8 jurors plus 1 or 2 alternates, and then we can decide whether or not the alternates deliberate or not. That's another question. Any other questions about jury versus bench trial? It really is you deciding who's the decision maker. Is it going to be me or is it going to be 9 people?
The decision's up to us?
He's open to either a jury trial or bench trial, so that means it's your choice.
Well, this is the first time we got a choice of anything since this all took place.
Kind of refreshing.
All right. Do you want to think about it or do you want to decide?
We'll think about it.
Okay. Any other questions I can answer about that so you have an informed decision?
How is the jury pooled? Just randomly?
From DMV records, voting records, things like that. Will be members of Maricopa County residents.
And we get a chance to question them. Is that how it works?
Yeah, that's a good question. So what we do is we'll bring in probably 30, 40 people into this room. They'll be sitting back there. They'll be numbered. I go through a lot of questions and try to find out if they have hardship issues that would make it too hard for them to serve. You know, if they're the sole caretaker of somebody, or if they're going to have some severe financial hardship, they'll lose their job if they spend time on the jury, things like that. I'll ask those types of questions, and then there'll be a time where you'll be able to ask the questions too. What type of questions are allowed to be asked? I mean, you don't want to bias the jury right off the start. Exactly. Right. That's a good point. So it'd be kind of yes/no questions, and you gave me some proposed voir dire questions that kind of hit the nail on the head. Both of you did. Things like, have you ever been involved in a case relating to a dispute about who owns property? Anyone in your family ever been accused of or been involved in elder abuse type crimes? Just kind of yes/no questions, and then a juror would raise their card, and you'd say, "Okay, tell me about that." So you don't really, like you said, poison the well. You try to just learn information from them to decide whether or not they've got some sort of bias that would work against you.
definitely wouldn't be fair if all of a sudden all the jury is biased from before you hear anything about the case.
Of course, right. That's the idea. That's the idea, is to get a fair jury pool. But, it's human nature. You don't know everything.
Yeah.
You have jurors that will insist they can be fair, and they're seated, and sometimes they can't. Sometimes they want to be on a jury, So it's unpredictable.
Question.
I'm sorry?
How much are we going to be restricted on testimony and evidence in front of the jury?
The same restrictions would apply with respect to evidence presented to a jury as it would be to me. So
you're not letting our evidence in.
Well, we haven't talked about your evidence, I don't think. But we can talk about your specific evidence.
Okay.
But it'll be the same standard, whether it's a jury trial or a bench trial.
Okay.
All right. We don't need any interpreters. Anyone have any disabilities? How about your client? Any issues with your client's mobility or anything?
No.
All right. The rule of exclusion has been invoked. That means any witness that is testifying will have to wait outside. They can't be in here. We'll assume that we've got a jury trial for the rest of this hearing, but you'll let me know if you want to change to a bench trial. Jury trial, we start at 8:30 a.m. on the first day.
We would love for him to get his courtroom experience in front of the jury. That's what this has been all about.
All right, let's stick to the agenda. 8:30 a.m. start on jury selection. Other trial days will start at 9:30 and end at 4:30. Take a lunch break from noon to 1:30. But most importantly, 8:30 a.m. for jury selection. And we'll bring the jury over here around 8:45 a.m. thereabouts to start the process. So I've explained a little bit how that jury selection process will be. We'll have, as I said, members of the public here. I go through lots of questions. I'll give you time to ask your questions that you've proposed. And we'll excuse jurors for hardship and for cause. And by cause, I mean they can't be fair. We determined from their answers that they can't be fair. And those will be issues I'll get your input on, and then I'll be the final decision maker on who's the jury that we seat. But I'll take your proposals on who we strike, or who we remove, and why. The trial itself will proceed with Mr. Eastin putting on his case first, as he's the plaintiff with the burden of proof. His witnesses will testify one at a time. You'll have the chance to cross-examine those witnesses, and then he'll get a chance to redirect, ask questions after your cross-examination. Then when Mr. Eastin rests, it'll be your turn to put on your evidence. It'll work the same way. We'll have to talk about the best way for each of you to testify. It's kind of nice that there's the two of you. So what I would suggest is, Mr. Casavelli, when it's your testimony, you'll sit at the witness stand and you'll ask the question, and vice versa. Otherwise, it's just kind of awkward to ask questions of yourself or whatever. And he'll have the chance to cross-examine you.
Is it too late to add a witness?
Okay.
Is it too late to add a witness on our witness list? Because I forgot one.
We can talk about it. Mr. Eastin can object based on timeliness, but yeah, it's probably too late.
No, it's been on every disclosure statement since it started. So.
All right, let's talk about that now. I have your witness list. Plaintiff intends to call 14 witnesses. Is that right, Mr. Eastin?
Potentially, Your Honor. Probably 5 to 6 will be the primary witnesses, but we may have to have rebuttal witnesses and or foundation witnesses.
Okay. And the way this would work is Mr. Eastin will have to give you notice at least 24 hours notice on who the witnesses are going to be for the day of testimony. So you'll know who the day one witnesses will be, and sometime during day one you'll know who day two witnesses will be, and you'll have the same obligation coming back to him.
How else do you notify us?
By phone, in the courtroom. All right, and your witnesses, you've listed, the only ones that only one I didn't recognize was Louis Cota, C-I-T-A. Who's that?
He's an ex-bank employee for BBVA Bank.
Is that like a custodian of records type?
He was the personal banker at BBVA Bank.
Okay.
In 2017.
All right, and what witness do you want to add to your witness list?
Christopher Adams.
I'm sorry, one more time.
Chris Adams.
Chris Adams. Who's Chris Adams?
He's an ex-tenant of Gartner LLC.
And what would be Mr. Adams' testimony?
He pretty much knows everything that's went on that caused this litigation.
Any objection to adding a witness?
Yes, I would object to that.
That's not right.
Mr. Adams, as far as I know, and nothing's been disclosed about it, I don't know that he knows anything about the claims that are going on in this case. If he's had knowledge and they've known about it and they've withheld it, then I would feel prejudiced at this point, Your Honor.
Your Honor, he knows everything. He's been informed of everything. In fact, it's been through every motion in the court for the last 7 years.
And it has been every disclosure statement.
He knows Chris Adams is aware of the situation, this entire litigation, and what caused it, and what took place after it was filed.
It would be a prejudice to us.
He actually sued Chris Adams in Superior Court here. And there's things that he has disclosed in that litigation that Chris is well aware of concerning this litigation. That's why he's needed as a witness and should be allowed as a witness.
It was just an oversight on our part.
Your Honor, that prior litigation that referred to took place before this litigation ever began.
No, Your Honor, it did not. The same time.
Like I said, one at a time. Anything else?
I stand corrected. It started before this did, but it did not conclude before this started.
I hired him to do that.
For that case.
Okay, and tell me again what Chris Adams is going to testify about.
Motivation to this lawsuit, what we were accused of in his trial, or litigation throughout there, what Mr. Eastin said about us that brought this litigation on. He said a lot of stuff in that trial. It's CD 2016-09633.
And
he actually named us on the joint pretrial report and motion to dismiss counts 3 and 4. He put our names in there, of course. And then he said that he could slander us because we were witnesses, but we weren't witnesses. And Chris knows this, and Chris is aware of the information that Mr. Eastin stated about us in there that wasn't true. In fact, one of the exhibits or evidence for understanding is Mr. Adams' affidavit of what Mr. Eastin said to him, because apparently he liked to talk about this case with Mr. Adams. And
what relevance is that to the claims in this case?
Because the claims he was discussing in this case is discussing with Mr. Adams.
Mm-hmm. It's in the court documents, what he said.
Okay, let's talk about exhibits. You've each individually marked exhibits. Plaintiff up to $117. So we'll need to mark plaintiff's proposed exhibits through 117, and then defendant's exhibits will start at 118, and we can't have two exhibit ones, in other words.
I understand, but he wouldn't tell us what.
I understand what happened.
We don't have a clue.
So, and that reminds me of an issue I wanted to bring to your attention, Mr. Eastin. I wouldn't presume to tell you how to try your case, but it looks pretty complicated based on the pretrial statement. There's lots of different claims. Any thought about narrowing the claims to the extent they're overlapping?
I've not thought about that, Your Honor. Yeah.
I don't have suggestions. I just noticed that there was a lot, and they seem to be kind of overlapping. And when that happens, sometimes the juries get a little confused, and you end up losing them. If it's simplified, you have a better chance at a jury that understands what the claims are.
Understood, Your Honor. I'll give it some thought. I don't know what the court needs in terms of a response to that. I don't know if we need it now or it can be something I respond to after I speak with my client.
Well, one of the things I wanted to do at the end of this conference is to set another conference. We can do that one telephonically if you prefer, or by Court Connect, and we can talk about it at that time. About a month out from trial is what I was thinking. All right. The exhibits listed by plaintiffs, most of them are bank records. I saw a few that were emails. Emails, of course, are hearsay unless there's an exception, and the exception might be, admission or something like that. But have you thought through those exceptions or those types of objections?
Yes, ma'am.
Because the court obviously is going to independently. I'm not going to wait for an objection on hearsay. I won't let hearsay in if it needs to be excluded.
Understood.
Okay.
All right. You don't let hearsay in?
I'm not going to let hearsay in.
Really?
Unless there's an exception.
So emails are hearsay?
Emails are hearsay unless there's an exception.
And yet he's been submitting them for 7 years and winning his motions.
At trial. Talking about at trial. A hearsay is an out of court statement offered to prove the matter asserted in the statement. There's exceptions like an admission. So if there's an admission in the document, then it's a hearsay exception. So I'll look into that. All right.
So if you admit to something in the email, it's an exception.
That's one exception to the hearsay rule, which is an admission of a party opponent. The other exhibits look like business records. Right. So plaintiff's exhibits, I think, I haven't seen them, so I don't know. But what I would like you to do is review their proposed exhibits and let the court know what objections you have to them.
Well, that depends on if you're going to allow his subpoenas to stand, because we have 2 subpoena histories said he never served any. So the bank record production, and there's a couple other documents in there. There's a lot of documents been changed, but there's a couple of documents that says exactly where he got the production from. And it's not possible to obtain them through a subpoena. That's why we ask to preserve records, because what he submitted, a couple hundred pages of altered records. And we stand by that. And we know this because some of the documents he's claiming that he obtained through a subpoena, not possible when the bank says they never Never.
And that
Produce anything for a subpoena from their side.
That goes all the way up to Alabama State Banking, which is BBVA's authority. And even they stated that Mr. Eastin never got subpoenas from the
They
bank.
said they don't know how he obtained the records.
Okay. Mr. Eastin, any thoughts on how to get over the authentication hump?
They've made these allegations throughout, Your Honor, and they've brought motions in front of the court, and all the prior judges have ruled against them on those issues. As far as did we serve, we did. We obtained valid subpoenas, and we served them on a bank. We have a process server who's produced an affidavit that will testify to that. The bank records were subpoenaed the subpoena was delivered to a local branch, and I think that's part of where their contention is. They think it should have been done at the national level or regional level, whatever the bank has. But it was served at the bank, they accepted it, and then they produced records pursuant to that. And we obtained them in a valid manner. There's no issue there. We have an affidavit of custodian of records.
Okay.
They're valid.
You may, but I'm going to suggest that, and you can say whatever you want about it, but I'm going to suggest that you put so that I can digest them and understand them, put your objections to the exhibits in writing, file that with the court so that I can have a record and read through it and understand it. But go ahead and say whatever you want.
We have a recording from the bank branch manager, and he's only referencing one subpoena to U.S. Bank. And the branch manager, the recording says he couldn't find the subpoena. And then we called the U.S. Bank branch at parallel at the subpoena processing and talked to Ms. Shannon Miltner. And she stated exactly how any production was given on that one, that Mr. Eastin called up and then emailed the alleged subpoena to them. And his affidavit is a year later after production, which he stated that if there had been a subpoena, the affidavit would have come with the production at the time. There's issues of how he obtained those records from U.S. Bank. We're referencing BBVA Bank, where there's no history. And there's Bank of America records that he finally, a few weeks back, given production to a disclosure statement that he obtained from Adult Protective Services here from an investigation, because when he filed his complaint, he had a copy to the Attorney General, which they set up an investigation because of financial exploitation, who they then obtained the bank records, which he submitted those to us through the financial statement, where there's handwriting notes on there that states a lot of things, but yet he would not allow us to obtain Bank of America's records or Wells Fargo, which is exactly where a lot of finances relating to this case was.
Okay, so what I'll do is ask both sides to submit within 10 days from today objections to the proposed exhibits from either side. Yeah.
I guess the issue I have is how can Mr. Eastin state so matter-of-factly that he obtained these subpoenas at branch level when every authority of Compass Bank at the time said that they could not, after an extensive investigation, could not discern how he got these records because they said there was no subpoena from them. The only ones they have is ours.
There's a simple solution. They could produce the originals that the court issued, because obviously that if he served one upon the branch, he would have two conformed copies, or one original and one conformed copy. And he has nothing, and if you look at the seals, okay, there's issues with that. It's amazing how the alignment is on the conformed copies are identical, and it's amazing how the Lincoln seal on the so-called original that he said he didn't have when we asked this back in 2018, he didn't have, yet in June of 19, he submitted to BBVA Bank, and they immediately sent us a copy of it, and you clearly see it's not right.
Okay, I'll review both sides' objections to the exhibits. And I appreciate the argument. I understand it.
Well, that's just the beginning. That's just the subpoena. He had 6 months He obtained these financial records from BBVA and apparently U.S. Bank in August of 2017 before he filed this. He didn't disclose this to us until April of 2018. And he had 6 months and he altered them. Clearly altered because we know our bank account.
Ms. Johansson even said that they got the records from U.S. or Compass Bank at branch level in August before this was filed September 6th.
Okay. Yeah, please help me by making your objections in writing.
We have the originals of our subpoenas.
Okay, understood.
So why shouldn't he?
Thank you. You want to add anything?
Yes, Your Honor. They brought these issues to Judge Cohen probably 4 or 5 years ago, Your Honor.
And he didn't listen to them.
And the Judge Cohen at that time said, look, even if I did something wrong with the subpoenas, which I did not do anything wrong with those subpoenas, that the judge ruled that I was entitled to.
No, Your Honor, he did not. No, he did not.
All right, don't interrupt. I'll let you talk, but you got hold on, one at a time.
He's lying.
I'm not lying.
He's flat out lying.
Hold on.
7 years he's done this.
Hold on.
The judge said I had to lay proper foundation for the records that I obtained. Okay, but that is different than what he said, that I was entitled to those records. That as part of the evidence in this case, I'm entitled to go get bank records to prove my case.
No, Your Honor. He's getting 2 judges mixed up. Obviously, he can't remember. He's getting district court judge mixed up with what he said. And Judge Cohen. Judge Cohen said if you're going to use those records, he's not making a decision, but if you're going to use them, they have to meet foundational requirements.
That's what I said.
No, you're sitting there saying what Judge Tilburg said to you, that as long as they're discoverable, you can use them, and that's not true either.
All right. I'll look at your objections in writing, and that'll help me give me more clarity.
When do you want those?
10 days from today. All right.
Well, email to here or just
file them as you would any other court document.
Are we talking 10 business days, Your Honor?
Yes, 10 business days. All right. So I'm going to divide the time equally between plaintiff and defendants. And that means you've got to keep track of your time. So if you use up hours and hours on cross-examination and you end up not having any time on your case, that's a problem. So keep track of your time. It's really easy to get carried away and lose time before you really need it. By the time of our next trial management conference, our next conference in early September, I'll let you know what those time estimates are for each side. But it's just roughly equal time between the 2 sides. And I want to make it clear to you to be careful with that, because it is, I've seen it so many times where people just run out of time. And
I'm used to the sleight of hand trick. I don't know.
What does that mean?
Well, it's all about throw out a bunch of lies. That way you don't deal with the issue at hand. So I can ignore the lies and get to the heart of the problem.
Okay.
I learned that from Mr. Eastin.
Talked about jury selection. I'm going to set for jury selection an hour and a half for each side on your own questions. Like I said, I've got my own questions. The time limit for each side will be 90 minutes. I think you can do it a lot faster than that, but I want to get this I want to have a jury seated. My goal would be by noon that first day. Any issues with an hour and a half, Mr. Eastin?
Not conceptually. I just don't know practically if it'll work. Just a lot of jurors to have to question. So
yeah, and if you get a talkative juror, which will surprise me a little bit, but if you get a juror that goes on and on, I'll be flexible with each of you. If you have to get a juror that talks and talks and talks and talks, I won't ding you as much on the time. What I'm trying to avoid is that going on longer than it should. The other thing to keep in mind is we're going to seat a jury of, let's say, 9 people. We're going to have 40 people in the room. We'll get a decent idea about whether that first 10, 12, 15 people are going to make it onto the jury, because that's who I pick. I go from number 1 to whatever to get a jury. So if number 2 is excused for hardship and that's it, then the jury's going to be 1, 3, 4, 5, 6, 7, 8. So there's not a lot of reason to talk to juror number 40. In fact, you can probably not worry so much about the higher numbers of jurors. Does that make sense?
They're all going to be here at once, right?
Yeah, they're all going to be in the same room.
So it shouldn't take 90 minutes, then.
I don't think so, but I've seen it go on. Which is why I'm trying to avoid that. And like I said, I'm going to be reasonable with both of you. If I'm not going to at an hour and a half tell you, bang the gavel and say you're done. And that's another issue for both jury selection and once we have a jury. You'll find that I'm going to go out of my way to be as invisible as possible. And this will be your show for the jury and your show for the jury. I don't want to do anything that would make the jury think that I'm leaning one side or the other, or that I believe one side or the other. So I'm going to avoid, to the extent possible, saying things, getting angry with people, or telling you to stop arguing or to stop talking over each other. But I'm probably going to have to do that. I have a suspicion.
Is he going to recite the case to him?
Who?
Judge Eastin, like he did in his proposed.
We're going to need I would read that statement. Did you prepare? Yours is too long. Yours is 5 pages. The idea of a statement to the jury is a very short summary of what this case is about.
Well, then one way to sum it up, lies. Because you want me to explain, this is what happened. That's what happened.
The idea is so that the jury can hear what this case is about, so that they can say, oh, I can't be a juror on that because I was involved in a very similar situation and I can't be fair.
Okay, then how do I cut it down when his actions caused this? Mr. Easton's. His very actions caused it.
That's not the point. The point is to just describe what this case, as neutrally as possible,
right.
is what this case is about.
That is it. I mean, I can try to shorten it down, but...
Well, let's look at what... Because my first read of it was it... Why don't we do this? On that same deadline, 10 days from today, each side prepare a short summary of the case to be read to the jury, and I'll attempt to meld them together.
How short? How many pages?
Like a paragraph.
It can't be done.
Okay. Well, it's going to be done. I'm going to do it.
7 years.
Then why not say anything? Because it can't be done.
Do you understand the point of what
I
I'm saying?
understand the point, but I'm telling you, it can't be done.
It's so involved.
The paragraph, he's told him the complexity of the claims and stuff, and yet you're not understanding the complexity of what.
They don't even understand the complexity of it. This is a question for all of the prospective jurors, so that they can understand what this case is about. That's all.
Okay, a false claim filed against someone who did their job.
In your opinion, it's a false claim. That's what you're saying.
I did my job. I'm still doing my job. And yet I'm being sued for it.
It's for the jury to decide, right?
But you won't let me state to the jury what took place. What you're telling me now.
So let's compare that to your opening statement. Your opening statement can be your summary of what you think the evidence is going to show. You can say all kinds of things.
Again, you hold the keys to the evidence, and if you're not going to let me put my evidence in, I can't say anything either.
All right, so I think we're just getting a little off track here. Well,
it's trying to make sense of this, of what you want, and I can get it down to a paragraph. If you want it one page, I get it one page.
All right, in 10 days, do that for me. And again, just to be clear, the point of this one paragraph summary, along the lines of what I have here on pages 1 and 2 of Mr. Easton's pretrial statement.
We don't know what that is. He never showed it.
Nope.
He
didn't give copies.
To accept 2019.
This was filed with the court on February 6, 2023. The pretrial statement.
It's changed since then. He even said so.
Okay. So the idea of the summary is simply a short summary of what this case is about, so that the jury can hear it and understand what they're being asked about. That's
okay. Question. You keep saying that this summary about what this case is about, but yet there's 12, 13, maybe 15 claims in equity that aren't jury triable. How can you not keep those out if he's going to keep them in?
Okay, so on the summary, we don't need to get into all of the different types of claims, what all the claims are. Just a basic summary of what this is about, so that a juror can hear it and say, yeah, I can't be fair, or yes, I can be fair on a case like that.
Okay. So
this is a case about being accused of something.
It's here and there.
Yeah, for example, the way that Mr. Easton worded, he said plaintiffs allege that they were impermissibly taken advantage of. We can add defendants deny, things like that.
Well, see, this would have happened easier if he had been cooperative on a joint pretrial.
Okay, but here we are. So I'm simply going to order.
But stating that we raped and pillaged old people is just not what I'm going to agree to.
Of course not. So Mr. Easton, if you want to stand by the statement you have, you can do that, or send me a new one. And I'll look for your proposed statement. I'll try to work with both of yours to get a short summary of the case for the juries.
Okay.
The jurors.
I think I understand what you're asking.
Okay. Thank you.
This is including what we're alleging too, right?
I'm sorry?
The statement of the case is what we're alleging too, right?
Because we do have a counterclaim.
You have a counterclaim for quiet title. The rest of the counterclaims were dismissed.
And then why is he going for quiet title when he lost it in summary judgment? We did lose it. April 8th, he lost it.
Mr. Easton filed a supplemental the day we had the hearing. Then he filed a motion to reconsider a couple of days later. If he won summary judgment and quiet title on equitable mortgage, he never would have wrote a reconsideration of the ruling.
Okay, so two things. On the counterclaims, all but one were dismissed. I've read that order. On his claim, and I'll of course look at this in a minute and I'll hear from Mr. Easton, but I think he was moving for summary judgment so that he can have a summary judgment on that claim. He lost, meaning that claim goes to the jury. Am I right about this, Mr. Easton?
That's correct, Your Honor. That's not what Judge Cohen said.
That's what it says in the order.
Judge Cohen stated...
I'm not done with this if this way it's going to go, so just do what you're going to do against this, and we'll just deal with it afterwards. How's that? Because it's ridiculous.
Just like this, he said that he denied them on summary judgment and granted for us. It's on video. I put the transcript in.
June 14th, 2019 was the video hearing.
He come out with it. I ruled against plaintiff on a very important issue of quiet title.
Okay, I will look at, you say it's the June 14th, 2019 hearing?
Yeah,
I will look at that.
The transcript in there. It's short.
We submitted the video. You don't see this stuff that we submitted?
I'll review that hearing again, all right? So that I can better understand what you're talking about in this.
Otherwise, why did he put in a motion to reconsider Judge Cohen's ruling if he won?
He even asked his client if they wanted to appeal the decision.
In fact, he said Judge needs to correct his mistake and rule for the plaintiff. I thought that was quite presumptuous myself.
So how are we this far if he's lost that? And Judge Cohen said this. I don't understand why we're still here after 2019. It still doesn't make sense.
Oh, I forgot. When you bring equitable mortgage to a trial, the rules state that you don't bring it. No one brings it to a trial without anything in writing. And Judge Cohen, over an hour, asked him for what he had, anything in writing, even if it was just on a napkin, and he produced nothing. That's why he lost equitable mortgage and quiet title. It has to be in writing, and he didn't do that.
So how do we lose something we won? This sounds like a 2020 Trump election, if you want to know.
Yeah, there's lots of orders here, and maybe I'm wrong. I'm going to look at them again.
Please do.
All right.
His motion to reconsideration on that is quite interesting.
All right, thank you. Now we'll hear from Mr. Eastin. Go ahead.
If I may, Your Honor, the judge primarily ruled that there were issues of fact that made it inappropriate for a motion for summary judgment to arrive at judgment. That's why he said we lost, because he felt like there were issues that needed to go in front of the finder of fact. That was the central holding there. There was no, and when he referenced that he made a ruling in favor of the defendants, what he meant was he denied the motion for summary judgment. So no judgment was entered one way or the other, but the claims still stand, and they're supposed to go to the
judge. He said that they were guilty of statute of frauds because they had nothing in writing when they claimed equitable mortgage. He kept asking Mr. Eastin what he had in writing, and he said nothing. There are deposition excerpts. That's not a writing of a contract of selling land that he proposed an equitable mortgage.
And
that's the reason why he lost this. It's a $2 almost hearing, April 8th. It was a summary judgment hearing, April 8th, 2019.
I thought it was June 14th, 2019.
That's the one where he said that he awarded in our favor. But the hearing, the April 8th, 2019, was the actual hearing where you see everything.
Okay, so the June 14th is the written order that you're referring to.
It's where he stopped us, what we were saying, and he told us that he awarded in our favor because I kind of made the judge upset. And that provoked him to tell me how he ruled in our favor.
I'll take a look at it.
Both of them or which one?
Both.
Okay.
The actual summary judgment hearing was on 4/8.
April 8th, 2019.
And then the order was not really until June 14th?
No, he issued the order, I think, on April 10th or something. But it's where he reiterated to us that we won.
Now I understand. Okay.
He spent a considerable amount of time not grilling, but asking repetitively what Mr. Eastin had in writing that would show his proof. We understand how the minute entry works, okay? And if it's not clear, it's not on the record. We understand in the review that minute entries are what's looked at, not the case files, okay? And because the judge don't want to put something on there clear, it doesn't mean these guys here in this corner are not recording what's happening, and that's where it's at. Okay, him stating this that he didn't lose summary judgment is wrong because he did. He brought quiet title and equitable mortgage, and he lost them. And my understanding is when you do that, it's a final ruling. It may not be a final order, but it's a final ruling on those two claims because they have been adjudicated. Now, am I wrong on that?
Well, yeah. Typically, if you're moved for summary judgment on a claim saying, as a matter of law, I win, judge, that's what you're saying. If the judge says, motion denied, I deny your motion for summary judgment on those claims, that ordinarily means that those claims don't prevail on a motion for summary judgment and instead go to a jury.
Then why can't we move the court to amend our complaints to add statute of frauds? Because they lost some judgment on quiet title. And
maybe there's lots of things that could have happened back then, but now we're here.
We ask, he says no. Court goes with him. He tells them stories. We're liars. He's the honest one because he's a lawyer. We're not. We're the accused. This is how it works. 7 years. We see how it works.
Okay.
Why can't we file it and fix it and just amend it? Because we've never got to amend the claims since Judge Cohen allowed us to have them.
Although he says
we had discovery for the short time, but we wasn't allowed to amend them. When we did, Judge Cohen stated that it was fully briefed and oral argument on the motion to amend our claims is appropriate. Well, due to an issue that caused an appeal, and Mr. Eastin went on vacation, and then Judge Flores taking it upon herself to strike our counterclaim from the record, at Mr. Eastin's urging, though, on the motions to strike that were already adjudicated on, he filed on the 13th, and June 14th of 2019, Judge Cohen said if anything else needed to be to refile. He didn't, and he talked with Judge Flores, and he got our counterclaim stricken. We never ever got to amend those claims.
Just to be clear on why we never got to amend, our first attorney, a 45-year attorney, that what he did when this case was filed, Mr. Hinkle filed an answer, but
not completed.
He forgot to finish it. He didn't answer all the things in there, and he didn't even sign it. We realized it the same day and put in an amended answer. And from that point on, he's been saying ever since that we already amended our counterclaim because it was called an amended answer. Because that's what Judge Cohen said for us to call our counterclaim. File an amended answer to include a counterclaim. And ever since then, he's blocked every single effort to amend.
And yet, the same thing will come to him. He put the wrong information in the plaintiff's complaint, and Judge Cohen told him to file a notice of errata on a claim.
Instead of just fixing
an amendment.
the claim.
It's just how it was circumvented. We don't get the same treatment.
Okay. There are 6 motions in limine. Do you have the motions in limine?
Not with, but I remember them.
You remember them? Do you want to submit written responses to those 6 motions?
We did.
You did. I didn't see them on docket. Can you email those to our division?
Sure. They're there.
We put them. We've been having issues with filing things, and they don't get.
Well, I don't want to rule on them until I have your responses. So would you get those to me, please?
They're within the time frame.
Your Honor, they are on the docket. I reviewed them yesterday.
I couldn't find them this morning.
I think they were filed in mid to late February.
Well, thank you, because I obviously want you to get your take. So you filed responses to all 6 motions in limine. Okay, terrific. Would you mind? She found them. Your docket is huge. It is
600.
It's a lot of pages, so I apologize. Terrific. I will review your responses.
Question about that.
Yeah, go ahead.
Blanket? A motion is for one piece of evidence, isn't it?
Not
Or a type of evidence, yeah.
Type?
Yeah, it could be a type of evidence.
Like
Preclude all evidence about X issue, that kind of thing.
So he could knock out 100 recordings that would prove him.
Yeah.
Those recordings.
What about?
Okay, you want to talk about any motion in limine in particular?
January 23rd conversation. I think it's motion number 1. Number 1. Yeah, he would know. Yeah. He claims it's attorney-client privilege. It's not. He's questioning the Johansons if I exploited them. They're not asking for legal advice. They didn't ask him to do that. In fact, an officer out of Washington State asked him to do that. He wasn't retained for that. Okay? It's public record. Ninth Circuit said it's not attorney-client. District Court said it's not. Even Arizona Supreme Court said it's not because they didn't rule it out. The issue of it is it's a conversation contradicting everything he states in this claim.
And he talked to us on Friday and told us that he wanted Nick to tell the Johansons that he wanted a conference with them, okay, on Monday. On Saturday, we saw the Johansons, which actually was the day Trump was inaugurated. Anyway, they were there, and we were talking about the meeting. They said they were fine with talking to him on the phone. And Donna herself asked if Nick would help her put a recording on the phone, an app that they had on before because of her grandson, so that they could record the conversation with Mr. Eastin so that we could hear it, because we told them we couldn't be there. They had to do it on their own.
There's a reason for that. And it's because of the investigation out of Washington.
Who
the officer asked him to question. He didn't really ask him. He offered to the officer Holt to question the Johansons.
And one of those recordings is Donna asking to have that recording put on her phone so she could record him. One
of our evidence is the Burlington, Washington police report, where he's actually stating we didn't do anything wrong. Mr. Eastin stating that.
To the police department.
And his response is before he found out. There was nothing to find out.
And this is in your written response to number 1?
Yes.
Okay.
And the recording that she got on January 23rd, they came over afterwards and gave it, told us to get a copy of it off the phone, and we did. It's not attorney-client privilege when they initiate it and then give it to us. Besides that, he's still agent for the company.
Which apparently he's trying to remove that from me in my pay that's due.
There's a lot of nuances to this case, Your Honor, including not having standing to bring it in the first place due to the new LLC Act of 2020.
It was there before.
But it started in 2015.
All right, anything you want to say, Mr. Eastin, about your motions eliminating?
Yes, Your Honor, it's attorney-client privilege conversation.
Where's the engagement letter?
Attorney-client privilege is usually held pretty much close to sacrosanct, and it was a conversation with my clients at the time regarding a trust that Mr. Johansson helped administer, and it was all in that context, and it did not have the conversation took place about the same time as what we allege Mr. Casavelli and Mrs. Casavelli were taking advantage of the Johanssons. So they're trying to exclude it, but I was trying to deal with other issues there that had come up because of this investigation in Washington, which I believe they may have instigated.
No, Your Honor. He instigated by closing the trust and awarding the money to Gary Johansson. He basically exploited Gary Johansson's sister-in-law, who was in an assisted living home in Washington, Burlington, Washington, because he told Gary to close the trust and award the money to himself under hardship. This is part of the whole thing here. That warranted and caused a criminal investigation against Gary. He injected himself into the investigation. And that's why the January 23rd conversation. He injected himself into the investigation because he didn't want Burlington, Washington to discover what he did with the trust. Gary and Donna Johansson have never had a hardship, and Gary said so in his deposition.
All right. So that's anything else on the motion to eliminate?
The recordings, okay? There's a lot of recordings, audio recordings, where the Johanssons ask us a lot of things, told us a lot of things in relation. It's contradictory to what he says. And they're even talking about him. Now, that could be hundreds of conversations that could be omitted, just wiped out with one motion, but they're on different topics, such as how they obtained the quitclaim deed that they're saying, he's saying they didn't give. Of course, Gary said he did, so did Ms. Johansson.
And you've marked these recordings as exhibits?
Some of them, yeah. There's a lot more of them. I mean, it'd take pages upon pages to produce all of them, whatever's needed. But I'd like to reserve them for produce them as needed.
Right.
I'd like to reserve one for my own self. I would like to reserve the one with Mr. Eastin where we asked him September 15th of 2017, what are they alleging? And he said that he couldn't tell us what exactly they're alleging in the complaint, but he proceeded to tell us what the complaint entailed. And I asked him, well, what are they saying about the house and selling the houses then? His words were that there's nothing in the complaint about power of attorney or fiduciary, anything that's not lawful. I'm paraphrasing, but Mr. Eastin said in September of 2017 that there was nothing that was done improper in terms of power of attorney or fiduciary, which power of attorney has never been used.
This is what he stated after he filed against us.
Yeah.
But the issue with these recordings is they contradict him, and they also prove that Johansson's, what they did was willing and truthful.
Okay.
The January 23rd conversation we're talking about, where he's saying it's attorney-client, he says any conversation with them is attorney-client privilege, and it's not. We understand that. One of the reasons it caused the notice of suggestion of death here recently is because I called him and asked him, finally got him on the phone after like 40 tries, and he says, I just simply asked him one question. When was the last time you spoke to Mr. Johansson? That's attorney-client privilege information. No, it's not.
But he just put a motion into you that said he never said that he told us that she wasn't dead. I've got the recording where he says, I'm not telling you if she's alive or dead because it's attorney-client privilege. Who's the one lying? We're not. We've had everything to back up what we say.
Okay. All right. So I'm going to read your responses, and I appreciate the argument. The jury instructions, I have your version in Word. Thank you. Mr. Eastin, can I get your jury instructions emailed to me in Word if you haven't already done it?
I think we did it back in February.
Okay.
But
May have.
I'm happy to
I'll ask.
necessary.
Martha's looking at me skeptically.
But I don't have any of their jury instructions. I don't have a copy of their pretrial, Your Honor. I don't have a copy of that witness and exhibit list I think you referred to earlier. None of those documents have been provided to me, so I don't have anything to look at here that you have to do.
They were sent to him. Of course, this is, see, he wants to play that he don't have agree to electronic service, and yet when we send him mail, and then we submit a postal receipt, he says it's a generic receipt. It doesn't state what you mailed. So there's the game that's been played numerous times. It's a 4-step game he plays, and it just goes round and round for 7 years. So he gets notified. In fact, he wanted to make a claim that I think the motion for sanctions wasn't signed, but that was only sent by an email.
I'll ask Martha to forward the email or file it, but forward it to counsel. You emailed me your Word versions of those documents.
Would that include all the documents that we just talked about, Your Honor, or just the jury instructions?
My memory is that it was the pretrial statement, the jury instructions, and proposed voir dire.
And the statement.
I have no problem saying to him again. It's just the fact that he just keeps doing this.
Okay.
We asked him about electronic service, and he refuses.
His idea is if he can make us look bad on the minute little things, he does. And it just causes extra expense, like it has.
Well, I'm a lot less concerned about that. I'm concerned about getting this case to a jury and then managing a jury trial. So I want to move forward in the most efficient way possible, and that would be.
Are you going to allow the non-jury claims?
We're going to have the non-jury claims. I thought we went through this, and I apologize if we didn't. The jury is going to resolve the jury claims, and I'm going to.
Not jury triable by statute.
The claims that, for example, a claim for injunctive relief, let's use that as an example. The jury's not going to resolve that claim. I am.
Okay, but we didn't waiver to take it to the bench.
We've never put a waiver.
The jury's going to resolve all the jury claims.
But then why do the rules say different?
Well, talk to a lawyer. I can't give you any legal advice or.
Should we look for the conductor to have our ticket punched in? Because this sure looks like we're taking a ride on this one. Because you guys get to do everything you want to us. Okay? You hold a hearing a day early, court does, and we wipe out all of our counterclaims when there's an appeal and the judge didn't have jurisdiction. And yet you say that our claims are gone, but his are all there, and the ones that you don't have a right to a jury trial is going in front of a jury.
When there's no waiver, but yet he asked for a jury trial. And
then you say, hey, let's let this go before a bench trial, and we're supposed to trust that? Nothing against you personally, Judge, but I don't trust this system.
Then you should go with a jury trial for sure. Okay.
Well, I'm just saying, if there was just something that shows it's balanced out a little bit. But do you realize when the last time we had anything ruled in our favor? Do you know what year it was? 2018.
All right. Well,
ever since then, everything has been a landslide against us.
Oh, I'm sorry you feel that way.
No. Why should I feel it? It's the truth. Look at the docket. There's 600 different motions on there, and you can see most of them through the million issues. Denied, 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 denied. It's what we get. And we can't even get the documents preserved because you just denied that one too.
It would make so much more sense, and we could understand it so much better if when you do write your denial, at least tell why you denied it, so we understand why.
They don't agree with it.
No one ever does.
That's just it. They don't agree with it. But I get that. So if we say we want to go with a bench trial, so really, our evidence, what are you going to leave out? What are you going to leave in? We have a lot. There's a lot over 7 years that's accumulated.
Well, I have your exhibit list. I'll look at the objections to that.
One of them there is his entire disclosure. Okay? He made 15 disclosure statements. One of them is his forged subpoena. Are you going to allow that in? I'd like to show that picture to the jury of the stamp that's on it.
He wants the production of the subpoena, but he don't want you to let the subpoena in, which makes no sense.
If you're suggesting, and I'm trying to track and follow you, but are you saying you want to use the the subpoena to impeach the witness about the records?
The subpoena is forged, plain and simple. It's forged. It was never, but the court says they don't have a record of it. The bank doesn't say they have a record of it twice over through subpoena histories and statements through the CFPB, the Alabama State Banking Department, through claims and complaints there. They have no history. They keep stating and through multiple recordings that they don't know how he obtained this. But the documents he put in a disclosure statement says exactly where they came from. That's why we call Louis Cota as a witness. Louis Cota is the one who produced the documents alleged from a subpoena he sent at branch level.
Gotcha.
Oh, yes. I do want to rebut what you said about the subpoenas being done at branch level. Compass is not U.S. Bank. A subpoena can be served at U.S. Bank to any representative. Compass Bank, now PNC, but BBVA Compass, you have to go to the legal department. And it's the legal department who told us that that was not real.
One of the exhibits in there for evidence is the invoice for his alleged subpoena. He's subpoenaing supposedly Garpdon LLC, but yet BBVA Bank is billing Garpdon LLC?
A non-party?
Who didn't request a subpoena? There's issues.
And the number the bank says is not belong to him. It's a request, not a subpoena.
See, there are so many issues around every one of his documents. It's like horrible.
I look forward to reading your objections. Let's talk about a few practical issues. This is the old courthouse. We're limited with technology. I don't know what technology you have planned. But if you're going to, for example, use a laptop to show a PowerPoint or something, that's what that little dongle is in front of you. You would plug that into a computer, and it would display on this screen. Do you have video depositions, or is it?
Yes.
You have video
Mr.
depositions?
Johansson's is a video deposition.
Sorry?
Mr. Johansson's is a video deposition.
Okay, so that might be something that you want to talk about playing.
He's going to say it's not, but the transcript actually reads it's a video deposition. So,
is it a video or not?
It is, but it also hasn't been transcribed, so both.
The official record is court stenographer.
Right.
But we have the video. It has been submitted to this court.
Okay. Well, that was one example of kind of technology issues. All right. If you want to test any technology, make an appointment with Martha, and you can come in and kind of work how you would work through the courtroom and the technology.
That'll also display documents too, okay?
It will. Yeah. Okay.
We're not going to play a 4-hour deposition right now.
Sorry?
We wouldn't play a 4-hour
If you want to bore the jury, that's one way to do it. Put them to sleep.
By no means is this deposition boring, Your Honor. But there is key points we would like to show.
Doesn't matter how exciting it is. The juries don't love watching hours of video.
Wouldn't be hours. No. Just a few highlights. It's actually more of a comedic reel than anything else.
Right.
Believe it or not.
Your Honor, some of the portions they want to use in that deposition don't have anything to do with Gary Johansson testifying.
Actually, it does. Actually, it does, Your Honor.
It's things that are stated between counsel and opposing parties. And that's not evidentiary.
He brought it. He did.
It's in the motion in limine, one of the motions in limine, I believe, I filed. So.
This would be a check for that evidence, because the fact that it's a video deposition, we should be allowed to use any and all parts of it. He spends 10 minutes of it trying to give me legal advice, and I tell him, just continue asking your questions. And it finally gets to the question I'm trying to ask Mr. Johansson, and he answers it for me. But it took 10 minutes of fighting through Mr. Eastin to get to that point. And, it's just kind of comedic where he states he's not aware of Rule 30, being a lawyer for however long it's been. But I'm supposed to get my little law book and point it out to him, because he's not aware of that, and especially when he gets caught recording it. He's recording the deposition and never notices that's on there too. That's kind of, amusing. But that's the stuff that in between him doing that, I'm trying to question Mr. Johansson. Okay, and it's all woven in there, and he wants to leave all that out where there is questions in there that's actually pertinent. Because Mr. Johansson does answer between his interruptions.
It's Gary's deposition. Every question is directed at Mr. Johansson. How could he say it's not?
Okay. All right. I'll look at the motion limiting and the response on that and the other issues. Let's set a status conference for September 8th at 10 a.m. if you're available at that time. We'll do that on Court Connect on the virtual format. September 8th, if that works.
I'm checking, Your Honor. Give me a minute, please.
Yeah, take your time.
Status conference?
Yeah. Just want to keep us on track and address issues.
You said September 8th?
That's right, 10 a.m.
Right?
Yeah.
That's really good for us.
Is that okay? Mm-hmm. All right. So at that time, for example, we'll talk about the exhibits, getting those ready for a jury, marked, as I said. Talk about any lingering exhibit objection issues, witness issues, anything that we need to resolve before the trial.
Okay, so he's objecting to Mr. Adams then, or did you make a decision on that, adding Mr. Adams, Chris Adams, as a witness? I mean, he has a lot of information about this, and it would be a prejudice to us not to allow him, considering he is very much aware of the statements Mr. Eastin made to him. In fact, it's even on public record on that, where he's stating it in Mr. Adams' case in the Superior Court. Well, supposedly we stated it.
This is Chris Adams?
Yes, Christopher Adams.
And you're... Well, why don't we do this? Because I want to make sure we have everything you want to say about Mr. Adams instead of putting you on the spot. By that deadline that we've talked about for exhibit objections, can you also put in your position regarding Chris Adams?
10 business days from today.
Yeah.
10 business days. Is the exhibits allowed on that too then?
Is what?
Exhibits allowed on that?
On
statements? On the statements?
Oh, you want to attach exhibits?
It shows that what was stated in court by Mr. Eastin about Mr. Adams.
It helps you understand.
As long as it's not, what are we talking about? A few pages? Or?
Well, I can take the excerpts out that only have the pages because it's a joint pre-trial report and a motion to dismiss that's got those in there. If
you're referring to, for example, another place where you've disclosed him as a witness for a trial, that would be something I'd like to see.
Well, it's where Mr. Eastin said we was a potential witness, but he's actually in trial, and Mr. Eastin is making statements about us at Mr. Adams' court hearing to the court. So that's where, if you want the whole thing, one of them 18 pages. I can just take out the excerpts and put it in there as an excerpt and mark it as that.
Well, if it's something like a disclosure, you can just give me the whole thing.
Okay.
All right.
Your Honor, pardon me. I said September 8th, but I didn't catch the time.
10 a.m.
You said we're going to do it remotely?
Remotely, yeah.
So we're to get our objections to evidence and a statement of the case.
Statement of the case and the Chris Adams positions on Chris Adams.
He's known we were going to call Chris Adams since the first disclosure statement, so there should be an issue. I can put that in there too, one of these disclosure statements, if you want, where our ours that we...
Whatever arguments you think I need to hear. All right. Productive. We're getting there. We're going to get to a trial in early October. The kind of the lingering concern I have, and I understand your position on why you want a jury trial, and I get it, and you're right. You have a right to it. I'm concerned about, and maybe this wouldn't happen with a jury, but there's still, like, when Mr. Eastin when he's up here making his opening statement, if you're chuckling or interrupting him, laughing, getting animated, the jury's not going to appreciate that. And I'm not, and I told you, I'm going to be in a difficult position because if I start telling you to sit down and be quiet, the jury's going to start getting the misimpression that I'm favoring one side or the other. And I don't want to do that. So you don't want me getting involved in anything when the jury's up there. So that to the extent you can restrain yourselves and just put on your case the best you can for the jury, put on your presentation, convince them, persuade them that you're right and they're wrong. That's where you're going to win the day.
Okay. So then why are these guys?
I'm sorry?
Why are these guys back here? It's not me.
Guys?
The police officers back here. What's the point of that? See, he tells the court that I'm violent, and it's like, you know what? He antagonized the situation in deposition.
Okay. Well, I don't want to get into that. I just do you understand what I'm saying?
Sure. There's no need for security.
Right.
I'm
worried, but I'm focused on just the optics of a jury. I want the jury to have this case fair, and I don't want them to hear me telling you to stop laughing.
I know the jury instructions states that his statements aren't evidence. Okay? So they're to go on the evidence. Okay? So if we object to the evidence and the statements.
You can object. I'm not telling you not to object. I'm just asking you to do it in a professional and courteous way.
I understand that about it, okay, but you understand something here. We have dealt with his
I get it. I understand this is. I've known from the first time we've had a conference that I knew this was an emotionally charged issue, but and I've been fine with it. I'm fine with it. But when it comes to a jury, if you're laughing at something he's saying, we're going to have a problem.
Well, if he's going to lie about us and it's funny, I think.
You're going to have a problem. If you start laughing, I'm going to stop it, and the jury's not going to like it.
Well, here's the issue with this, okay? His statements are not true, and if I'm not able to rebut those statements that with the truth, okay, because everything he's accused, he's got nothing to support it.
All right.
And we've asked this for 7 years to get the evidence, and he won't give it to us. Yet he asked us to provide this.
So if he has no evidence to prove his case, that's what you'll be telling the jury.
So you're right. It is very emotional and very supercharged because what he's alleging is heinous, and we're members of the clergy.
So if he can't prove his case, you win. And when you're hearing things that you don't want to hear and that you don't like hearing, you have to just let it be heard. That's the jury's entitled to hear it.
I understand what you're saying. I understand, but the thing is, he's comical with his statements because they're not even accurate, and yet he doesn't have anything to support it. Just like he said, he proved Mr. Johansson is alive. Okay.
All right. So
we didn't get that information.
I understand.
How come we don't get this information? And when we tell the court says just look it over and you don't have to give us information. Why are we excluded from that?
Well, I'm not sure I understand specifically what you're asking, but if you're asking why the court denied post-disclosure deadlines discovery, I think the orders are clear.
We asked how come he didn't give the disclosure statements until just a few weeks ago. He didn't give the exhibits with those disclosure statements. He gave the disclosure statements, but he didn't give the exhibits. And then when we find out that there's Bank of America represented with handwritten notes from Ms. Joanna Dockstader, who investigated this back in 2018, that totally refutes his statements here, he just gives them. We copied the division on this email with it, and so it's unacceptable. It's unbelievable that you would wait this long to disclose this to us. And yet it's okay. It's okay for him to do something, and yet nobody says anything. And we haven't been able to argue that evidence until 3 weeks ago, or whatever it was when he sent it. And yet it's moved forward.
You forget he told Judge Cohen in a hearing just like this one that he got his client's Bank of America records, but he chose not to disclose them because he didn't think he deserved them.
Just like he's on Bank of America. The issue of it is that he held the exhibits on the disclosure statements till a few weeks ago. He kept saying that he gave this in disclosure. In the disclosure, he did not. We asked for him. He actually put it up on a Dropbox, or whatever you want to call it there, and gave us a link to it. We downloaded it. And then when we've seen this, like, this is unbelievable. You kept this from us for 5 years. And we haven't been able to even, and now here we are.
I guess that'll be in your response to the, or the objections to the exhibit.
How are you supposed to respond if you give the disclosure statement alleging all this stuff with all these JLH members, and yet no exhibits to back it up? How are we supposed to deal with that? And then we asked him about it, and he refuses to give it.
And then you're saying that when it comes to discovery here that we're denied this discovery? He denied us for 5 years to even refute anything.
So, Mr. Eastin, help me understand the production of exhibits.
Your Honor, we produced, I think, an initial disclosure statement plus 15 supplemental disclosure statements over the course of the years that we've been litigating. At the time that any disclosure statement was made, my paralegals or legal assistants sent those out and with exhibits. When they brought these accusations up, I went and checked with my legal assistants to confirm that it was done that way instead of through a link or on some electronic means, and they confirmed that they did send those out with each one. And then on top of sending it out in the mail, on most of those, we also sent an email to them with electronic versions of the disclosure. We're not required to do that. We did that as an additional measure.
Okay. And can you produce those at trial to show disclosures, timely disclosures?
Yeah, I've got copies of the emails. I sent them actually to them. I produced all the emails that showed that they were timely or simultaneously provided to them. Because
I can't resolve a timeliness issue unless I have that sort of.
Your Honor,
I can produce all my disclosure statements, and those all state that the exhibits were mailed at the same time.
Okay. We submitted an email to it when he gave us that link. We copied the court in on that and stated that there is no email. We received no email from Lisa O'Brien or whoever it was on all these dates because we have not. Okay. One of these exhibits he said he mailed to us, 483 pages. I think we'd know getting a ream of paper in the mail.
Okay.
We did not.
Well, we'll resolve that with the other exhibit objections. I guess we will meet again. Thank you for your time today. Adjourned.